Well, thank you, ladies, for joining me on this conversation and welcome. My name is Oluwatobi Ogundele for Econolicy Africa. And on today's conversation, I have an esteemed panel from the ESCC, that's Eswatini's Competition Commission. So on this conversation, our theme for discussion is going to be about protecting Eswatini's markets. And before we go into the questions, I would like to give the beautiful ladies the opportunity to introduce themselves to us. So I'll start with Siboni. Can you tell us a bit about your journey in competition law enforcement and what your current role is at the ESCC?
Thank you, Oluwatobi, and thank you for the invitation to have this conversation. We're very honored and appreciative as the Competition Commission to feature on such an amazing platform. Like you've mentioned, my name is Siboniselizulu. A lot of my colleagues know me as Siboni. The only person who calls me Siboniselizulu is my mom when I'm in trouble, which is not very good. I've been working in the competition space for about 14 and a half years now, closer to 15. I started with the Eswatini Competition Commission in 2011, and I was with the commission here for 5 years before I went and worked with the COMESA Competition Commission in Malawi, where I was there for about 8.5 years. I've recently come back to the Eswatini Competition Commission. I'm currently the Director for Competition and Consumer Protection, which means our technical functions that assess mergers, investigate anti-competitive practices, as well as look out for the protection of consumer welfare fall under my supervision. My work at competition level nationally and regionally spans across assessing mergers, investigating anti-competitive conduct, as well as investigating consumer violations. So I'm very happy to be here. Thank you.
Well, thank you for that beautiful introduction and that overview of your journey. And I'll give Nontobeko the 30 seconds opportunity as well to tell us about our journey in competition law enforcement and what your current role at the ESCC is.
Good afternoon, Toby. Thank you so much for having me. I really appreciate the opportunity as well. My name is Nontobeko Dlamini. You can call me Nono. I currently occupy the position of Senior Economist under the Policy and Research Department of the organization. My work, I have a background in economics, and I've been with the Commission, this particular organization, for a period of more than 8 years, and I've been attached within the Policy and Research Department. So my work involves conducting research in different sectors of the economy, but I've also conducted or assessed a few major transactions within the Commission. Thank you.
Thank you. Thank you for that introduction, Nontobeko. So, ladies, we'll be going into the questions that we have for you today, and we hope our viewers, our listeners will glean from your experience in this area of enforcement, especially from your work at the ESCC. So the first one is just about the history of this agency, of this institution. Can you share with us a bit about the history and just the challenges, if any, faced in having a fully functional competition authority in Eswatini, and how were this overcome? Siboni, I'll give you the opportunity to kick us off on that one.
Thank you, Toby. So the Competition Commission is a creature of statute. We were established by the Competition Act of 2007, and we began our operations in 2010. Before we started our operations, we were working as a function under the Ministry of Commerce, Industry and Trade. And I mean, to the best of my recollection, the very first merger we assessed was around 2008 or 9, when we had a merger in the petroleum industry, when a Portuguese company, Galp, took control of Shell Corp, which used to operate in the country. So we've been operating as a standalone entity and not a unit under the ministry since about 2010. The challenges that we've had are really not unique to us as a competition agency. They're not unique to the country. It's mainly got to do with resources. We rely very heavily on a government subvention to run the work that we do. We have, and that has its intended challenges with maintaining talent and making sure that we retain the very best of the best in terms of competition lawyers, competition economists. Another challenge that we faced pretty early on, but we were able to just kind of navigate the waters, was just to encourage merger notifications in the country. We do have a mandatory merger notification regime, and to this end, it requires compliance not only by the business community, but by their lawyers as well. And so we had very targeted interventions at the very beginning to engage the law society in the country, as well as the business community through the various chambers of commerce for small businesses, as well as the major chamber of commerce, which is Business Eswatini right now. Back then, it used to be called the Chamber of Commerce. And so we worked really hard to encourage them to comply with the law. Obviously, there were some challenges with having to pay with merger notification fees. We had a lot of businesses that moved to, apply that they should be exempt from paying the merger notification fee. What we have in our law is that small mergers don't pay a notification fee, but that large mergers would pay a particular fee, but it's capped. And so we had quite a lot of challenges also on jurisdiction. There were various interpretations of what our merger regulation covers, and whether or not some of the entities in the market are, whether or not their activities should be exempted under the Act, because we do have certain exemptions under the Act, and there have been entities that have engaged us to say, because of the nature of their institutional setup, some of them are creatures of statute, or some of them were sponsored by the government in some way or the other in their setup, they would take the position that therefore they would be exempt from the application of the Act. But with a lot of engagement, a lot of advocacy, and a lot of discussions, we've seen the sector come around. We do have state-owned entities that accept our jurisdiction, such that when they transact in the economy, to the extent that their activities would, fall under the enforcement of the Act, then they would they recognize our jurisdiction and they comply with it. The main challenge we have at the moment, Toby, is in regards to the amendment to the law, which is related to the national policy. Our law is about 18 years old this year, and we have been trying to have some amendments move forward, but the policy directive at national level is that we need to develop a competition policy first, so the law came before the policy. So the policy directive is that we need to develop the national policy, which will give us guidance about, what to include in our law. One of the big conversations happening is whether or not we need to have two separate entities, one for competition enforcement and one for consumer protection matters. And that is something that we believe that we will receive, the necessary clarity from the development of the policy. And then we can move forward about seeing how to amend our laws. And just to that point, Olu, if I may, we do have a dual mandate. We enforce competition, and we have a consumer protection mandate. And for the consumer protection mandate, we use the Fair Trading Act of 2001, as well as the Competition Act of 2007. And we've had some challenges there as well in terms of enforcing the Fair Trading Act, because it sets up a different enforcement mechanism than what the Competition Act set up, but we haven't had that many challenges with enforcing for consumer protection violations because of how our Section 33 of the Act on Unfair Trade Practices incorporates the Fair Trading Act.
Thank you. I think that was beautiful and just a detail in it. And because I've had this interview with other authorities as well, it's actually nice to be able to do that comparative, thinking around how your setup is similar and also in some ways slightly different from, say, Zambia or South Africa. So thank you so much for that nice overview of the ESCC's history and where you are and with the amendments. And I hope all goes well with the amendments, because those are really important. Because as times change and markets change, it's definitely important to revisit. At least I'm a strong believer in revisiting, those laws and making sure that they are fit for purpose. So thank you for that overview, Siboni. So kind of shifting gears to one of the functions that the ESCC has. My next question is for Nontobeko, and it's on research. So as a senior economist in the Policy and Research Department, what do you feel, and if you had to mention maybe 2 or 3 important reasons why research should have a very solid position in any African competition authority? I mean, what would those reasons be? And I'm asking this because we have some authorities that don't necessarily separate out the research function, having that separate department. So if there's any value or benefit to having that you've seen from your work at the ESCC, could you, shed some light for us on that as well?
Okay, thank you so much, Toby, for that question. So, as you have mentioned, yes, the Competition Commission of Eswatini does have a research department, and we conduct research. In terms of the Act, it states that we should conduct studies and make available to the public in terms of the operation of the Act. So, but in terms of its importance within the competition space, I move the view that it is important because research provides a holistic view or overview of the different markets. It provides a holistic overview of market dynamics, changes in the markets, which as opposed to mergers and acquisitions as well as investigations. It also gives, because in terms of also timelines for us, I think for investigations, it's like 90 days and then you can request an extension. But in terms of research, at least you can be 2 years or so. So you try to gather as much information as you can and also give direction for the commission or for any other competition authority in terms of enforcing the competition law. For us, even though our law, in terms of the findings of the research that we conduct, even though our law does not give us or allow us to use the findings as evidence in terms when adjudicating matters, but we do flag out issues with the other departments, especially the cutters and enforcement, to indicate that competition may not be working well in this particular sector or market, and then we can take it from there. So I think having a standalone research department is important for competition authorities. So I think for those competition authorities that do not have, they might have to consider that because, as I've mentioned, it provides a holistic overview. And just to make an example, we have also, as a commission, have also recently started to conduct what you call concentration level market assessment or scanning. So I think it also helps to understand how markets are concentrated within the different sectors of the economy. Thank you, Toby.
Yeah, thank you for that response as well. And while I still have you, we're moving on to mergers. And I know Siboni kind of touched on it a bit when she was talking about the first merger with Shell Corp and the other organizations. So now we're coming more to your assessment framework. So we know that competition authorities want to ensure that mergers are not anti-competitive, right? And they don't lessen competition in defined markets substantially. So how do you at the ESCC assess merger transactions? What are the kind of key considerations that are in your framework for assessing mergers? And then following on to that, so say you do an assessment and you find that a merger could potentially be anti-competitive, what kind of remedies would you put forward to address, those problems?
Okay, thank you so much, Toby, for that question. I think also Siboni can also add in some of the points that I'm going to make for this one. So we assess as a competition authority, we assess major transactions based on international best practice, such as the ICN or International Competition Network, as well as the OECD, amongst other organizations that we follow. And then in terms of the assessment, what we consider, we have legislation, regulations 2010. We have a particular section of regulation which states the elements that need to be considered when we assess a major transaction. So in terms of that regulations, like Regulation 17. So in terms of that regulation, we need to understand the relevant market. We need to define the market. We need to define the relevant market, and then also we need to understand the market shares of the merging parties, and we also need to understand the levels of concentration pre-merger and also post-merger. And then we also need to understand the entry and exit dynamics, as well as the regulatory framework, or maybe if there are any regulatory barriers in the market, yes. And then also we need to understand the availability or assess the availability of the substitutability of those markets, of those markets under consideration. And we also need to understand the level of countervailing power, as well as import competition. And then in terms of our regulation, we also need to consider issues of public interest or public interest issues in terms of employment, in terms of also competitiveness of the market, regionally as well as internationally. And then we also need to consider the aspects of SMMEs. Yes, the aspect of SMMEs, whether the merger will not affect the entry of SMMEs into the market. So those are some of the factors that we consider when we assess a major transaction. And then in terms of the remedies, you may be aware or not, I don't know, but we do have the commission. So the
Probably
commission, yes, or not, yes. So the commission has, in accordance with the regulation, still on Regulation 17. So the commission has, we can allow a major, okay, we can approve a major subject to conditions, we can approve it without conditions, and we can prohibit a major transaction if we suspect that it's going to distort competition to an appreciable extent. So in as far as remedies, we have put, or we have, we use structural remedies as well as behavioral remedies, but we have used mostly the behavioral remedies, whereby we put conditions to say this is what is expected from you. You are not allowed to discriminate when we suspect that the major transaction might or has the potential to distort competition in the near future. And then what we've also put in place, we do monitor their conditions. Yes, we do monitor the conditions in terms of adherence. And then also after a while, a period of like 3 to 5 years, we then conduct an impact assessment just to check how the market has changed. That's where research comes in. That we've connected, well, I shouldn't say a number, various impact assessments of major transactions that have that we approved subject to conditions. Thank you, Toby.
Yeah, thank you
to come up.
Thank you for those responses, and you covered so much. Thank you. So I don't know if Siboni wants to add on to, either the assessment framework for mergers, or you wanted to say something about the types of remedies if you feel a merger could potentially be anti-competitive. I mean, feel free to add on.
Yeah, thank you, Toby, and thank you to Nontobeko. Gave a really, really comprehensive answer. What I would add in terms of our merger assessment framework is that we do have a framework under which we are given the opportunity to give input to regional mergers. So mergers that are notified at COMESA level under our MOU and under the obligations, under the regulations, the COMESA Competition Commission would invite us to provide our input into those mergers. The assessment framework in that case would take on the regional one, the regional requirements. So we would focus a little bit more on the substantial lessening of competition test, which is what Nontobeko started with, looking at the entry dynamics, looking at countervailing power and import competition as well. We would also highlight the public interest issues that would affect us as a country. And, that typically requires a bit of a discussion with COMESA on the public interest issues because they have to balance 21 member states, right? But on just an interesting one on the remedies, at national level, we haven't prohibited a merger, but we provided an input to the prohibition of a regional merger. And that was the Axo Nobel merger. Our contribution our contribution to that assessment was that it would have a significant impact in our market in Eswatini because of the emerging parties, the nature of the market in the economy. It was going to result in a significant lessening of competition for us, and that resulted in that merger being prohibited for Eswatini. It was a hybrid decision in that it was approved in parts of East Africa and prohibited in parts of Southern Africa, which includes Eswatini. I think it involved a prohibition in Zambia and Zimbabwe as well, if my memory serves me well. We've not had a prohibition at national level. And in terms of structural remedies, Nontobeko mentioned that we have, at national level, we typically look at behavioral remedies, and that's really due to a consideration of the context of our market and the nuance. But for a regional merger, we did contribute to the Heineken Distil merger, which saw a divestiture of one of the brands that were involved in that particular merger from Namibian Breweries Limited. We, in terms of remedies, right, at national level, then we've had behavioral remedies. But when we contribute to regional assessments, then we've had a merger prohibited and we've had a merger approved with remedies. Yeah, and then the public interest requires a little bit of a more nuanced conversation compared to what it would be at national level. Yeah, but what we would do is we would still use our framework to, when we engage with COMESA on our public interest issues, we would use the framework that's provided in our Regulation 17.2, just so that we're not, being ultra vires, as the lawyers would put it, but just so that we're not being greedy in our assessment of regional matters. Yeah.
Thank you. And I like that you brought in that regional element. And it's actually an interesting conversation because of the supranational competition authority plans with AFTA, and just knowing how that will kind of play in at the national, regional, and now maybe even continental level. So a lot to look out for in this space, I guess. Thanks for that addition. So while we have you, Siboni, I wanted us to move to the issue of market power and dominance, and in relation to investigations and enforcement. And in your experience at the ESCC, which contraventions have you observed to be the most recurring? And if you could give us maybe examples of one or two decided cases of kind of repeat anti-competitive conduct in a particular area, that would be very helpful.
Okay, thank you, Toby. We have posted some decisions of some of our decided cases on the website, so I'd also invite the viewers and yourselves and Econolicy to take a look and see what kind of cases we have adjudicated on. When it comes to abuse of dominance cases for us as a country, we tend to find that it's quite, I wouldn't say easy, but the size of our market makes it relatively more attainable for companies to obtain a certain level of market power or a certain level of dominance. Our Act considers dominance in terms of its qualitative nature. So we look at your market power and your ability to behave independently. We don't have thresholds as yet, which is something that we're hoping to see come in with the amendments, because parties that have been adjudicated on for abuse of power, they would always bring in the market share dynamics. But we do have a qualitative assessment as a starting point to say, when we are investigating an entity for possible abuse of dominance, then these are the factors that we would look at. So it is a qualitative consideration of what constitutes a dominant position in the first place. And so in terms of some of the abuses themselves that we've seen, we have seen conduct that is exclusionary in nature. So where a party refuses to provide a service to a particular sector of the economy, competitors, they would refuse to supply competitors. We have an interesting case that actually involved a company that was domiciled in South Africa that had engaged a distributor or an agent in Eswatini. And the way in which that relationship played out for us was that the South African counterpart would refuse to supply other competitors in Eswatini. And it was as a result of their vertical agreement, but in the context of our market, it did become an abusive case, because we looked at the size of the company and the kind of service they provide. So that was a case that we prosecuted, and the company we got an administrative penalty levied on the local company. We collaborated with our partners in South Africa in terms of understanding the market dynamics, in terms of also discussing, some of the assessment frameworks that we were looking at, because it was a conduct sitting in their jurisdiction but affecting ours. And so we've seen exclusionary conduct being a refusal to supply particular goods and services. Just last week, Toby, we adjudicated on another abuse of dominance case where we had a particular player that was refusing to provide a particular service to their stakeholder. That's as best as I can describe it now until the decision is issued, because we're such a small economy. So if I go into details, then
we'll probably figure out.
Yeah. But we tend to experience quite a lot of exclusionary practices. And the reason I started with the South African case is because a lot of companies in South Africa consider us to be, the size of our economy is comparable to a province nationally. And so they would prefer to engage with a single supplier. But what that does is, when we look at, when we define what the geographic market would be, right? And we take into consideration those portions that are outside our country, that abuse, it locks out some of the competitors locally. And so those are quite prevalent for us. Exclusive supply agreements are, they're quite rampant, and they really are blocking the ability of small and medium enterprises to enter. They're really raising barriers. And our assessment, because of our context, has been to approach them on abuse of dominance. And then the one that was adjudicated on last week, it was a local entity against local stakeholders. And so we look forward to a decision of the board on that one. I don't think we spoke about our institutional framework, and maybe that should have been in my introduction.
Yes.
Yeah. If I may, Toby, just like one little minute.
Yes, please.
What our institutional setup is, we have a secretariat that conducts the investigations, and then we submit our recommendations to our board of commissioners, which has the adjudicative function, but they also are policymakers. And this is not very different from many competition authorities across the region. And then they would make a decision, and the decision can be then appealed at the High Court.
Okay, so you'll be different than from South Africa. Do you have a competition tribunal? So if you were to go into litigation, okay, that's interesting. So it goes straight to the High Court.
Yes, litigation on appeal or on review, it would go to the High Court. But litigating it at the first instance, it means Nontobeko and I, even though we're economists, we would be able to present a case before the board, and litigate, so to speak, defend our case before the board. Yeah.
Okay, that's very good. Thanks for that addition. So we are on to our last question, where we can now relax. I feel like I've been grilling you with all these difficult questions, but this is still a difficult question. I mean, it's about women representation in the African competition space in Eswatini. So I wondered what advice you would give to women looking to come into this field and looking to flourish, grow in their careers, like you ladies obviously have grown. And do you get mentorship support? What organizations are you kind of part of that supports active women involvement in the competition space? So if you were to advise a young, fresh graduate looking to come into competition law, what would you tell them? And also the advice for someone already in the field that wants to grow in their careers. Specifically for women now. Let's talk about African women.
Okay. And specifically for being in the competition space.
In the competition space, exactly.
Okay. That's a tricky one.
Well, it wasn't as easy as I thought. So you see, ladies, it was easier for you to answer the competition questions. You were like,
we were much more prepared for that one because we went to the Act and we went to the regulations and we highlighted where all the answers were. What would we say to women that would like to join? The first one is, and I mean, I guess this is a universal statement. It's not necessarily confined to being in the competition space, but it would just be to pursue your dreams, work hard, put in the work to get the work done. We have, in the competition commission here, we have quite a lot of female practitioners. Our exco is 75% female, right? Management is at the moment 60% female. As you go lower down on the ranks, our seniors and our juniors, we do have quite a balance of females and males. Was this a deliberate effort by the Commission in terms of diversity and equity? I mean, not necessarily, right? We hire based on merit, and we don't discriminate according to gender. Whether we're tipping that balance towards one gender over the other, we really don't discriminate. So it is a meritocracy, and I would just say to women, work hard, let your work speak for itself. I think that's really, really important, because, you know, people experience each other differently. And if you're going to focus on who said what about what, then you're really going to not get very far in life. So let your work speak for itself, first and foremost. Let your work speak for itself, and try everything, right? Don't look at a particular portfolio or look at a vacancy or whatever the case may be, and look at the boxes that you don't tick. Look at the boxes that you do tick, emphasize those boxes, and give it a go. Give it a go, and then you know. Because if you don't give it a go, then you will never know. Yeah. Yeah.
Thank you. That was very inspirational.
True.
So, Nontobeko, any, advice for women looking to come into the space? What do they need to prepare for or to be prepared with? You can emphasize maybe the degrees. Must you be an economist or a legal practitioner? Is there opportunity for non-economists or non-lawyers to flourish in this space as well?
Right. Yes, thank you so much, Toby. And yes, to add on what Siboni has said, I think it's important for especially young women, especially those that are still at tertiary, to consider the competition space. I'll make an example for me, especially, okay, I have a background in economics and I didn't know anything about competition law. So, when I got engaged in the commission as a trainee, you mentioned the issue of mentorship. So let me just mention that we usually hire fresh graduates with a background of law and economics. So you are able to grow into the competition space. You're able to be like I did mention that I have an economics background and I didn't have any experience in terms of law or any law besides the competition law. So I was exposed to say, oh, this is such an interesting field. And I would encourage young people, especially those that are still at tertiary, to look into the competition space. And, I think also as competition authorities, we also need to engage with the tertiary institutions to encourage more students or more young women to come into the space. Because when you are still at school, you're actually directed to, I think, the macro level in terms of economics, the macro side of economics. So there's just limited exposure to the micro, which is, I think, which encompasses the competition law space. So I would encourage them to actually look into the space. It's such an interesting field, and it requires a lot of reading, and yeah. Yes, thank you.
Yeah, thank you, ladies, for those beautiful responses. And sadly, we've come to the end of this refreshing and packed conversation. And I'd just like to say thank you for your time, and to sign off with a quote by Siboni. She said, "Put in the work to get the work done." Thank you, ladies. It was amazing.
Thank you so much, Toby.
Thank you.